109. Should I offer to provide displaced workers with letters of recommendation?
Tough question. The short answer is no, but there may be exceptions or ways around this somewhat thorny issue. The reason for the initial no answer is simple: there is little benefit to your company in providing references about prior workers to prospective employers or headhunters. Yes, it would be the nice thing to do, especially after a layoff. After all, there's nothing you'd rather do than hasten employment for your ex-workers who will soon be in career transition. Even in cases where employees weren't very happy, helping them find productive work elsewhere could save you potential headaches from wrongful termination lawsuits. However, the downsides are obvious. Claims of defamation await you should you provide false or injurious information that precludes an ex-worker's gaining employment. Other similar types of claims that could be brought by a former employee include invasion of privacy, for the disclosure of private information. Statutory violations, for example, the California Labor Code makes it unlawful for any person by way of misrepresentation to prevent a former employee from securing other employment. Unlawful discrimination, for example, a former employee could allege that a negative reference was given because of her pre-termination objections to her former employer's unlawful and discriminatory employment practices. Negligence, for example, a recent California court ruled that, once a former employer elects to provide a job reference, the company must provide all relevant information regarding the former employee, both favorable and unfavorable. Of course, the truth may be an absolute defense to defamation claims related to alleged false and injurious statements, but not necessarily to discrimination, negligence, or invasion of privacy claims. You won't want to face months of litigation in order to determine whose version of the truth, yours or the ex-employee's, is actually correct. Without a well-defined policy prohibiting your line managers from granting reference information about ex-employees, you'll have a loose cannon on the deck of your ship. After all, you'll never know who's saying what about whom until that lawsuit crosses your desk. Therefore, create a policy requiring supervisors to refer all references to human resources for handling. You'll sleep better at night knowing that all the supervisors in your company are consistently protecting your organization from unnecessary liability every time their telephones ring with someone asking for information about the performance of ex-employees. Tell me more. If your company provides its employees with annual performance reviews, then those reviews, as long as they are signed by the employees, should serve as written proof of any ex-employee's strengths, weaknesses, and areas for future development. Simply provide exiting employees with copies of their historical performance reviews so that they can share those evaluations with prospective employers if they wish. Do not, however, forward ex-employees' performance reviews to prospective employers without the worker's permission. That would be inappropriate and could expose your company to liability. If you give your employees copies of their reviews, it will take you out of the middle. Performance reviews serve the purpose of evaluating a worker's performance, and that's all that prospective companies are interested in during the reference checking process. Managers need to simply tell prospective employers, "We typically give employees performance reviews once a year. You might want to check with John to see if he's received any reviews during his stay here. If so, he's free to share them with you if he wishes. Other than that, we're not permitted to engage in verbal performance references and have to refer all calls to our Human Resources Department." Problem solved. What if your company doesn't provide its employees with annual reviews? Then the whole thing becomes a little trickier. You do, of course, have the right to compose letters of recommendation for your employees. However, if such letters are to be written, they should be brief and based on factually documented information in the employee's personnel file, not on subjective claims related to performance. Even so, there is some risk with this approach because the former employee may disagree with your characterization of his performance. As a result, the former employee may allege that statements in the letter of recommendation are false and injurious. A sample letter is in Appendix W. Of course, you can simply refuse to provide any subjective reference information whatsoever and limit your responses to a. Dates of employment and b. Last title held. However, if you feel that such a stringent no references policy will hurt your ex-employee's chances of re-employment, you may wish to rely on a legal doctrine called qualified privilege to protect your firm against claims of defamation. Defamation comes in two forms: slander if the information shared is spoken, libel if the information shared is written.